Actually, good morning. Good morning. Yes. Okay. So, good afternoon for all. Good morning for our speaker, Professor Mihailis, our participants, and everyone who's watching us, whatever you are. Welcome. It's a great pleasure to learn from you today on algorithm misconduct and artificial intelligence, the accountability gap in corporate law. My name is Victoria, and here as co-organizers, I have my colleagues, João and Daniela, and also as debaters, Sofia and Gustavo. We are so grateful for all of you that are joining us today on this webinar. You are really a great part of this initiative to bring the business and human rights field to discussions in order to propose improvements and reforms. I would especially thank to Professor Paola Medellin and the students of the Diplomado en Compliance de la Escuela Libre de Derecho in Mexico. Thank you so much. Through the webinars that we are organizing at the University of São Paulo, we seek to address the problems increased by the COVID-19 concerning the field of business and human rights. Personally, I find this topic very exciting. Today, there is already a kind of algorithm accountability for dealing with potential harm to human rights caused by the use of algorithms in decision making. So in this context, the questions arise: does international human rights law already provide this framework to deal with the damage caused by the algorithms? Because the possibility of technology to create through big data predictive systems capable of harming human rights is an important element to be considered. So to present this initiative and the challenge and the current status of discussion, we have the pleasure to hear from Professor Mihailis Diamantis. He's Associate Professor of Law at the University of Iowa, and he has a PhD in philosophy from the NIU, New York University. All of our webinars are going to be recorded and available on YouTube if you want to watch it later or recommend it to someone. And without further ado, after your presentation, Professor, we will open a quick panel for questions to involve our debaters and participants to bring their remarks. Thank you so much.
Thank you very much, Victoria, and thank you to the organizers and to all of you for being here to discuss algorithms, corporations, and various kinds of misconduct. So thank you very much for being here. I'm at the University of Iowa. I teach about corporate liability, corporate crime, and for the last 3 years, I've been getting on this law and tech bandwagon. And so I've done a lot of writing about corporations and algorithms, and this is kind of the culmination of that trajectory of work that I've been doing. A couple caveats before I get in. I know that you guys are interested in international human rights law. And I have to say two things. First of all, I'm going to be talking about US law because it's what I know. I'm not an international lawyer. So if anything sounds unfamiliar, it might be because it is. I'm just talking about US law. And the other thing I'll say is I'm not talking about human rights law, actually, either, because that's not my area of specialization. But as I think you'll see, the types of harms that we're talking about here do resonate in a lot of concerns that overlap with both long-standing and perhaps emerging human rights norms. So with those caveats, if you want to step out of the room now, feel free to silently go out the door. Otherwise, I'm going to move on. So what I'm talking about here is an increasingly common scenario, which if you read any newspaper, you will have seen at least once in the last 6 months, many times in the last few years, where a corporation does something wrong, there is someone who is hurt by it, and the corporation's response is not to accept responsibility, but to blame the algorithm. We didn't know the algorithm was going to do this. It was just a glitch. It was just a programming error. We don't know why it did this. We're going to take it offline, or we're going to keep doing it, but hopefully do it better moving forward. Now, it's a problem which is prevalent now. It's a type of response that corporations use, and it's one which we're going to increasingly see in the coming years. According to several consultants who do work in artificial intelligence, they predict that over the next decade, up to 40% of jobs held by current human employees will be replaced by algorithms. And as the scope of algorithm functionality in corporations expands, you're just going to see more people who are harmed, more corporations blaming the algorithm rather than accepting any sort of accountability for themselves. Now, what kind of harms am I talking about? As I said, we're not talking directly about human rights harms. They're grounded in different types of law in the US here. But some examples are fraud and theft of the kind that you might see through insider trading. We have algorithms that execute stock trades on behalf of hedge funds, and they have learned to do things to coordinate with each other. They have learned to engage in a practice known as stock churning, which you cast a lot of purchases for a stock. It makes it look in the market like the stock is very desirable, so a lot of other people try to purchase the stock too. The price goes up at the last minute. The algorithm cancels the purchases and then sells the stock that it held already at the inflated price. This is stock manipulation, and it cheats people who are trying to support their retirement through the stock market. We're also talking about discrimination. This is a sort of a thing that Victoria alluded to in her opening remarks. Algorithms that approve mortgages or approve people for credit cards. You hear a story every month about one of these discriminating against one kind of minority or another, or not even a minority, a majority. Apple was recently, you probably know, was recently discovered to have an algorithm which was approving lending, credit lending to individuals and discriminating against women in its practices of extending credit. Apple's response, again, to blame the algorithm. We have algorithms engaging in anti-competitive practices which artificially force consumers to pay more for the goods. So retailers who sell their products on Amazon might both use algorithms. Competing retailers use algorithms to set their prices in real time on Amazon's platform. And they're smart algorithms, they're machine learning. They learn how to do their job better as they do it. And what's one way to make the most profit for the retailer for whom you're setting prices? It's to start talking to the algorithms of the other retailers and coordinating the prices. We're talking about privacy violations of the sort where algorithms suck up data and then spit it out, sometimes purposely, but a lot of times on accident as well, to a lot of people, invading the consumer's privacy. And we're also talking up to and including death. You've heard this instances about Tesla and Uber with their testing of self-driving cars and pedestrians who have been stuck in other automobile accidents that have occurred where there are real lives at stake. So these are the kind of harms that we're talking about. Now, the accountability gap, which is referred to in the title of my talk, is the legal mechanism that allows corporations to say, it wasn't us, it was the algorithm. And this leaves victims with no recourse when they suffer one of these harms. It leaves them with no recourse because A, you cannot hold the algorithm itself directly accountable. Under the law, algorithms are not people. They're not cognizable defendants for either criminal law or for tort law. And even if they were cognizable defendants, there's no way to make an algorithm pay any money. There's no way to deter an algorithm from misbehaving in the future. Our liability mechanisms just weren't built for algorithms. So the next place that victims might look and that prosecutors might look is to hold corporations accountable. But it turns out that's very difficult too, for two reasons, at least in US law. There is a requirement under our general principles of corporate liability that the plaintiff or the prosecutor identify a single employee within the corporation who engaged in misconduct. So you have to find one employee who committed the tort or who committed the crime, and then you can attribute that to the corporation and hold the corporation accountable. So under US law, it's tied to corporate liability is tied to individual employees. Now this leads to two kinds of problems when it comes to algorithms. One, which I call the many hands problem. This is the sort of situation that arises. Algorithms are very complex to develop. They take hundreds or thousands of employees, sometimes at multiple corporations, to put an algorithm online and to distribute it to the market. And even if there is a bad actor among these thousands of employees who are designing the algorithm and bringing it to market, it can be very hard to find out which one that is. because they're all engaged in a collaborative enterprise, inserting small lines of code, all of them making their own modules, right? And it can be hard to trace it back to an individual programmer. So this is the many hands problem. There are many hands involved, and it's an evidentiary problem. Even if there is a bad actor, it can be very hard to prove that for algorithms because of the complex undertaking that they are. That's one kind of problem that we have that leads to this accountability. The other is what I call the no hands problem. And this is not an evidentiary problem, it's more of a metaphysical problem. It's a problem that arises when you have an algorithm that causes criminal or civil harm, but there is literally no human employee who sabotaged it, okay, who is responsible for that harm, either through negligence or through purpose. Our most advanced algorithms are machine learning algorithms. They are designed. The whole power of them is that they behave in unpredictable ways, that they behave in ways that we cannot understand. We use machine learning algorithms rather than typical simple algorithms because they can solve problems better than we can in ways that we couldn't anticipate. But as they become more autonomous, as they become less predictable, we see that the algorithms can also behave in ways that we wouldn't want them to behave. That's the other side of unpredictability. You get unpredictable benefits, but you also get some unpredictable harms. And this can happen even if every single employee who's involved in training the algorithm, in testing it, in deploying it to the market, in updating it, is behaving in a responsible way. And so you have an algorithm that causes civil and criminal harms, but again, no individual employee. And under US law, that means you can't have corporate liability because corporate liability ties to the individuals. Now, this is a big problem. It's a big problem because, as I've said, it means that victims can't get justice. They can't have their wrongs recognized. They can't have their wrongs recompensed and get money to help them with the injuries that they're suffering. It's also bad because it means that the law cannot discipline corporations. How could we possibly get corporations to behave better with respect to their algorithms? Well, the way we do it in the rest of the law is we hold them liable when things go wrong. But if corporations get a free pass when they're using algorithms rather than employees, they have no incentive to do better, or at least they don't have that incentive to do better. And not only is this a problem, it's going to be a growing problem. I just told you about how the pace of automation in corporations is accelerating and expected to dramatically increase over the next decade. One of the reasons for this is that, well, algorithms are cheaper and they're faster than individual human employees. So corporations have a legitimate economic incentive to use algorithms. But there's another reason that corporations will prefer algorithms to employees and will transfer responsibilities to algorithms rather than employees, even when it's not necessarily cheaper and faster otherwise, which is as a tool for managing risk. Because if we have this liability loophole, why would a corporation have an employee performing a function when it can have an algorithm doing it instead and get some protection from liability if something goes wrong? They can just say, it wasn't us, it was the algorithm. So that's kind of the setup to the problem that I'm trying to address. And the one sentence solution that I want to offer, and I'll give more detail and build up to it in the rest of the talk, but the one sentence ambition is that I want to develop a model of corporate accountability, which I call the labor model, which will hold corporations accountable for algorithmic harms by treating algorithms just as though they were a typical source of corporate labor, by treating algorithms just as though they were employees for purposes of assessing corporate liability. If courts consider that algorithms are employees, at least for assessing whether the corporation has committed a crime or a tort, they can slot the algorithm into the existing structure of corporate liability. We don't need to find an individual human employee. We have an individual algorithmic employee, an autonomous employee through whom to run our traditional doctrines of corporate liability. So that's what I want to build towards. And I have a couple inroads, thematic inroads for motivating this type of approach. One of the inroads is just purely functional, just to look at how corporations are treating algorithms. Historically, corporate production occurred only through employees. Corporations ran only on human labor. So the doctrines we have for assessing corporate liability are specific to that historic context and that mode of production. They are tailored to employees, human employees. But now we see, just as an economic phenomenon, that corporations are replacing human labor with automated labor. And so what's the appropriate response? Well, just to have our doctrines of corporate liability expand to adapt to an evolving mode of corporate production. So that's one motivation, just kind of look functional. It's very high level. Another motivation is to look at our actual doctrines of corporate liability, see what the principles are behind them, and see whether, even though they apply currently only to employees, the principles that motivate them could also apply to algorithms. The doctrine we have in the United States for holding corporations accountable is called respondeat superior. I don't know if you have the same thing in Brazil. It wouldn't surprise me if you do. It's an ancient Latin doctrine. Francisco, would you please mute yourself? Oh, thank you. It's an ancient doctrine, traces all the way back to ancient Rome. It means let the master answer. It was originally used to hold slaveholders accountable for the misconduct of their slaves. Today, for some bizarre reason, it applies to corporations and their employees. And the rule for respondeat superior is that there are two elements. For a corporation to be liable for the tort or the crime of its individual employee, the employee must have intended to benefit the corporation at the time of the misconduct and must have been functioning within the scope of the employee's employment. Now, this plainly does not apply to algorithms. It wasn't developed for algorithms. It was developed in ancient Rome, so of course it doesn't apply to algorithms, okay? Algorithms don't have intentions, and so they never intend to benefit their employer, and they're not employees, so they don't have a scope of employment. But if we look behind these two elements of respondeat superior, we can see some deeper justice principles that are at play, which can be easily extended to algorithms if only at one higher level of abstraction. We have to get rid of the human-specific elements, and we can see how they would apply to algorithms as well. Now, one of the principles behind the two elements of respondeat superior is fairness. Okay? This is where the intent to benefit prong comes in. Respondeat superior is a mode of vicarious liability. That means we're holding the corporation, a separate person under our law, responsible for what another person, the employee, did. So that's vicarious responsibility. Ordinarily, that is an injustice. That's a kind of thing that the government has to have a very special burden in justifying that kind of accountability. And this is where the intent to benefit requirement in respondeat superior helps. It ensures that there is a rough alignment between the employee's interests and the corporation's interests. It helps ensure that the employee is the practical embodiment of the corporation because the employee is acting for the corporation's benefit. And what's more, by pairing these expected benefits with the expected costs of production, this just further enhances the fairness of respondeat superior, because it's only reasonable to expect that the party which is benefiting from some kind of conduct would also pay for the costs of that conduct. If the corporation is benefiting from what the employee is doing or expects to benefit, it should also pay the costs of that conduct, including and up to and including when that cost is an externality imposed on an innocent party because of a crime or a tort the employee commits. So that's how respondeat superior, through its intent to benefit element, promotes fairness, one justice value. Another justice value that respondeat superior promotes through its second element is deterrence. The second element is the employee had to be acting within the scope of employment. Everybody recognizes it's a basic economic principle that an agent can never fully control the individual that's acting on their behalf. A corporation can never fully control their employees, and we call these agency costs. What that means in terms of compliance and preventing misconduct and crime on the part of employees is that no compliance system can be perfect. There is no system a corporation can set up that will guarantee that going forward, its individual employees will always behave. So if a corporation can't control some employee misconduct, it doesn't make sense from a deterrence point of view to hold the corporation accountable for that. So how do we make sure that liability only applies when the corporation could influence what the individual employee is doing? Well, that's where scope of employment comes in. Scope of employment is a rough proxy for control. An employee roughly is working within the corporation's scope of employment to the extent that the corporation has control over what the employee is doing. And this assures that the penalties we're imposing on corporations truly can have some deterrent effect so far as their employees are concerned, because we're just sanctioning corporations for the misconduct that they could have prevented. So these are two general criteria, two general principles that are behind the intent to benefit and the scope of employment principles, elements of respondeat superior. The general principles behind them are assuring that benefits and costs are aligned together for the corporation, and to assure that the corporation is only held accountable to the extent that it had control over the employee. Now, at this higher level of abstraction, these principles are things that can apply to algorithms. Although algorithms don't have an intent to benefit and never have a scope of employment, a corporation can expect to benefit from an algorithm, can claim the substantial productive benefits of the algorithm, and a corporation can exercise substantial control over an algorithm. And this would assure that holding a corporation liable for what the algorithm does is fair to the corporation and will promote deterrence. So this mode of accountability we have for corporations, which is holding them responsible for what their employees do, has deeper principles that would justify treating algorithms in the same way. Now let me move to a third motivation. So I've talked so far about the functional motivation. Corporations are treating algorithms like employees. They're using them for labor. The second motivation looks at the principles behind holding corporations responsible for what their employees do and see that they extend to algorithms. And now here's a third motivation, which is one that I've been excited about in some recent work that I'm doing, but is to look at the history of labor law. Now, this move that corporations are making now to transfer functions from employees to a non-employee source of labor, it's a very old page out of a long-standing corporate playbook. In the US, at least, it was occurring 100 years ago. Corporations were using intermediaries to get around child labor laws and sweatshop laws. So they could benefit from child labor and from sweatshops, but the children and the people working in the sweatshops technically wouldn't count as the corporation's employees. They'd count as the employees of some intermediary. Later on, in sort of the mid-50s, mid-90s, pardon me, corporations and into the 70s, temporary work agencies became a big phenomenon for corporations. They would, instead of hiring their own internal employees, hire an army of workers from temporary agencies who would provide a reliable source of labor to the corporations, and the corporation wouldn't be responsible for paying any benefits to the employees, but also wouldn't be, sorry, not to the employees, to the temporary workers, but also wouldn't be responsible for any misconduct of the temporary workers because they weren't the corporation's workers, they worked for the temp agency. Most recently, we see it unfolding in the United States with respect to gig workers, the Uber drivers, the Lyft drivers, the Amazon truck drivers. the Airbnb, the shoppers, who go and do your shopping for you. Now, corporations are transferring, these major corporations, transferring functions from employees to gig workers, who the corporations say are not employees, but are instead independent entrepreneurs, working for themselves rather than working for the corporation. And again, they're doing this for two reasons. One, they don't have to pay any benefits. No health insurance, no minimum wage applies. None of these laws to protect workers apply. These laws account for 30% of total worker compensation. And by reclassifying these workers as gig contractors rather than as employees, the corporation doesn't have to pay any of that. But the second reason that Uber and Amazon are doing this, using gig workers rather than employees, is again to manage liability risk. They, in court, mount what is called a contractor defense. When somebody gets hurt by an Uber driver or an Amazon driver, Amazon says, look, this person, why am I being held accountable for what this person has done, for the accident this person caused? They aren't my employee, they are an independent entrepreneur who is doing some work that they have agreed. And so they're not my employee. Under our law, I can't be liable for what they've done because they're not part of my corporation. Now, this has been an ongoing story, this kind of a historical pattern that I'm trying to build up, of corporations transferring responsibilities from employees to non-employee work, in part motivated by the cost savings of not being liable when things go wrong. And in each iteration of this history so far, what we've done in the United States is we have expanded our concept of what employment means. In response to the child labor and sweatshop activities that were occurring, we passed the Fair Labor Standards Act, which broadened out the notion of who is an employee. You can't simply by hiring some paper-thin intermediary disclaim an employment relationship. What's on the paper doesn't necessarily dictate for the courts. Sometimes it's not Congress that's being active, sometimes it's courts that are being active agents in expanding our concept of employment. This is happening in California right now with respect to gig workers. The courts are looking at broader principles behind employment law and expanding them to encompass gig workers, both to get the gig workers benefits that they deserve as labor for the corporation, and also to hold the corporations accountable when that labor produces harm. And all I'm suggesting in this paper is that we do the same thing now for this next iteration of this corporate game, where they're transferring functionality from employees to algorithms, to non-human labor. So the general idea that I'm building up towards, again, I've called it the labor model, is that we should introduce this concept, expand the concept of employment to include what I call employed algorithms. An employed algorithm is one over which the corporation exercises what I call beneficial control. This is basically the same test that I was discussing with respect to responded superior, but adapted to algorithms. The court will first ask, does the corporation claim the substantial benefits of the algorithm's productive work? And here the court should look not just at direct benefits, like does the corporation charge consumers to use the algorithm, but also indirect benefits that a corporation might have. That does the algorithm gather data that the corporation uses to improve the efficiency of its platform, or that it then packages and sells to third corporations, right? So there can be direct and indirect benefits that a corporation gains from an algorithm, but the court should consider all of these, the economic reality of the benefits, in deciding whether or not the corporation satisfies the benefits prong of the test for the algorithm. And then the court should also ask whether the corporation exercises control over the algorithm. It's only if the corporation had some capacity to prevent the algorithm from hurting someone that it makes sense from a deterrence perspective to hold the corporation accountable if the algorithm does cause harm. And in evaluating control, the court should again have an encompassing conception of what control could be. They should look to various indicators of control, whether the corporation designed the algorithm or had the power to monitor the algorithm or modify the algorithm or terminate the algorithm, and many other indicia of control that a corporation could have. And if a corporation satisfies both the benefit prong and the control prong with respect to the algorithm, the court should deem the algorithm an employed algorithm and then hold the corporation accountable just as if an employee had engaged in that misconduct, had it caused those harms. So that's the basic idea. I have, as I said, this is sort of contextualized in a much longer project. So there are a lot of details that need to be built in for this labor model actually to take off. But maybe we can talk about some of those in the Q&A if they occur to you. So thank you very much for listening, and I look forward to chatting further.
Thank you so much, Professor Mihailis. You brought very enlightening issues concerning the problems and the consequences of the use of algorithms in different aspects, especially the dark side of this technology. So I must say that I share many concerns that you brought here around this topic and the complex consequences to legal mechanisms too. And I see here that we have a full house today with colleagues from Latin America, Mexico, United States, Europe, and thank you so much for your participation. And before we present our questions, I would like to invite our debaters, Sophia, and after Gustavo, and our participants to present their remarks.
So thank you very much, Professor Mihailis. I have here, I've read your article, The Extended Corporate Mind, but it's very enlightening hearing from you now. Of course, I get more doubts than certainties whenever I have such a mind-blowing explanation such as this. But I will try to summarize my thoughts and try not to make a fool of myself here, since this is not by far my field of expertise. So I'm really grateful for your presentation. And I couldn't help, when I was first reading your article, I couldn't help relating this theme with the many fiction movies and series that we have related to algorithms and how artificial intelligence could develop to something bigger than humans when it comes to decision making, and how in some ways artificial intelligence could overcome and overachieve things that humans can already do. So I think it is somehow, it's not a conspiracy, but it sounds like we could be facing a darker future if we don't think about it now. Since if I told my parents, I don't know, if my parents have been told by someone in the past that one day in the future I would be talking to a professor from the United States with my camera on my computer, they will be totally shocked. They would say, well, this person is a lunatic. Let's hold him in jail because it doesn't sound probable. It doesn't sound possible. But here we are, and in the past few decades, we have in fact faced this super technological development. So I think when we talk about artificial intelligence, we at some point will have to talk about robots and how this now algorithm software that is something abstract can or will be behaving after someone just gives birth to this robot, and how maybe someday it will in fact be able to behave as a human brain when we talk about conscious. That's the fact that technology can learn from its own mistakes and provide better solutions, and in that sense be someone, a human being, as we think about conscious. So I know that in your article you somehow disregarded the fact that at some point we should directly hold the algorithms accountable. But I would like further comments on that topic, especially thinking on this situation and the fact that I have a vacuum here at my home that whenever it's working and I just lift it from the ground, it tells me, please put me back on the floor. So I really would like further comments on that. And I will just make all of my questions so that everyone can participate. I have here 2 more topics. So I also would like a few comments on this, invisible victims when we talk, for instance, about social media and how the studies nowadays relate the increasing use of social media with also an increasing rates of mental health problems, especially in youth, and how, because in this particular situation, we have an algorithm that was built to have an outcome, and this outcome is somehow harmful. It has been shown to be harmful, but it will be also possible in another situation that when we think, for instance, in the algorithm that rates people for loans or mortgage, that you have really objective criteria, and for specific social situations, inequalities, this algorithm that was not meant to be discriminatory works in a discriminatory way. So how do we measure, what can we relate to that in terms of liabilities, and are those situations in fact different when we appreciate the value of the conduct? And my final question, I know, and you were very open in saying that you were talking about a US perspective, but here in Brazil, I'm afraid that we are not that pragmatic. And unfortunately or fortunately, our corporate liability in the criminal field is rather raw still. So it would be a pleasure to hearing from you whether you, from this algorithm perspective, think that criminal corporate liability is mandatory. It would be, in other words, it is something that we can no longer wait for it. We should implement it now, as we have the time for it. Because it will be possible in the future to work outside criminal liability, for instance, in regulatory liability, civil liability. What are your thoughts and insights on that topic? Yeah, once again, thank you very much. I could stay here talking the whole afternoon, but I'm sure that Gustavo, my friend, has also very interesting questions. And I know for a fact that many people here online are looking forward to pose their questions too. So thank you once again.
Thank you, Sophia. Victoria, is it okay if I just give some responses to Sophia before going to Gustavo, so I can remember them all?
For sure, Professor.
I'll be brief. I'll be brief. Thank you very much, Sophia, for all those thoughtful insights and for obviously the obvious work you put in, reading some of the earlier work I've done. You're right to be worried about a darker future on the horizon if we don't act now. There was a recent survey that Reuters, which is a polling company here in the United States, performed among a large group of technologists at a major convention, so people who work on exactly these issues. And they asked them a multiple choice question: will artificial intelligence benefit society overall, be neutral overall, or hurt society overall? And only 1/3 of them could say that they thought that algorithms on the whole would benefit society. So we're engaging in this major project, right? This major economic and technological development that the majority of people involved in it don't think will make humanity better off. I'm a little more optimistic, but I'm only optimistic if, as you suggest, we start taking some action anticipating the possible problems that we might encounter. Now, one of the problems that we will encounter, and this is kind of where your first question was going, about holding algorithms themselves directly accountable. One problem we will eventually encounter, if science fiction will it ever become reality, is that we will have algorithms that act totally independently. Robots that act totally independently. Robots that build other robots that no human even designed, right? And so we'll have robots who have, some claim, or seem to have some claim to being people, right? And without any third party to hold vicariously liable. Everything I'm talking about assumes there's some corporation in the background that we can hold vicariously liable for what the algorithm does. But at some point in the future, we're not going to have that third party who's going to be tethered to the algorithm. The algorithms will be designing themselves. My paper doesn't provide any solution for that. So what I'm talking about here is specifically holding corporations accountable, and it will help for the foreseeable future until we have algorithms that are moving and designing and everything totally on their own. There are some countries, including the European Union. I think Saudi Arabia just granted its first patent to an algorithm for designing a product. There was another Middle Eastern country that granted citizenship to an algorithm. The European Union is involved in discussions about whether to recognize algorithms as people. Personally, I think this is a very dangerous route to go down. There are, so far as I can see, only costs to humanity for doing that. One of the costs is we're going to implement this entire system for holding algorithms accountable, but algorithms, they don't have bank accounts. They don't have liberty. They don't have anything that we can take away from them to use to influence them to behave better or to help the victims of algorithmic or robotic misconduct. Maybe in some distant future, it's like the Jetsons, I don't know if you guys know the Jetsons. They have that maid who vacuums their house, and the maid, I assume, collects a salary, so maybe they'll have bank accounts, but that's way, 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 way in the future. Algorithms as we understand them now, we could set up a system of liability, but it wouldn't help anything. But there are also significant costs to recognizing algorithms as people who can be directly sued for any harms they cause, which is that with the responsibility of personhood come a lot of benefits of personhood. In the United States, we've made this mistake once before, at least a lot of people think it was a mistake, by creating an artificial entity, granting it personhood, and in addition to granting it personhood, giving it all the civil rights of personhood in a way that ended up conflicting with and minimizing the civil rights of real life flesh and blood human beings. And that entity is the corporation, which in the United States can claim every single constitutional right that they have tried to claim so far, with one, which is some minor one called the protection against self-incrimination. Okay, otherwise they get freedom of speech, they get freedom of religion, just as though they were other people, but they're much more powerful people, and their expression of these rights ends up infringing on the expression of the rights from real flesh and blood human beings. So if what we care about is promoting human welfare, I'm very skeptical about recognizing algorithms as people at any point in the future. What do we do when algorithms are moving around literally by themselves? I don't know. Let's talk again in like maybe 20 years, and maybe I'll have some idea that we can chat through. Your second question was, how do we about measuring discrimination with algorithms, and how do we think about that? How is it different with algorithms than it is with people engaging in discrimination? So we talked about some examples of discrimination in terms of mortgage lending, mortgage approvals, or credit card credit applications. In the United States, again, we have two ways to think about discrimination. I will just say, first, from the victim's perspective, whether they are discriminated against by an individual human being or by an algorithm, the effect for them is the same. They suffer a harm. They were illegitimately denied the ability to buy their house, or the ability to buy their groceries on a credit card, or what have you, right? So the injury they suffer is the same. Under the law, though, it's very different right now. Whether you have an individual human being at Apple who's discriminating against applicants, or you have an algorithm. Under US law, there are two ways to make a discrimination case. One is you have to show that the entity that was discriminating did it on purpose. So they have prejudice in their heart, right? Now, for an individual employee, that's something you can show, because we know what discriminatory purpose is for an employee. But as I said in my talk, algorithms don't have purposes or intentions. And so algorithms can never satisfy that prong of the discrimination analysis. There's another prong that victims of discrimination can use to push a discrimination case. They can say, don't look at my individual case. Look at a bunch of cases together, and you will see a discriminatory effect in the decisions that the company is making. Apple is approving applications of men more than women. You see a discriminatory effect. And that can be enough to build a discrimination case for an individual, but only if there is no business justification for that discriminatory effect. And the problem with algorithms is that it's very easy for corporations to generate a business justification, because the way that the algorithm is learning to discriminate is that it's designed to maximize profits for the corporation. And so the Apple could just go and say, if they were accused of discrimination, look, there has to be a business justification because we built the algorithm so that it would discriminate against people only if there was a business justification. And so in terms of the legal perspective, it can make a really big difference whether you have an individual employee or an algorithm that's engaging in discrimination, because a lot of people think it is virtually impossible to launch a discrimination case against a well-designed algorithm, or against a corporation using a well-designed algorithm. And then your final question was about this very, very interesting question about, in Brazil, we don't have a very well-developed law of corporate liability. I've been very fortunate to have some Brazilian students in the corporate crimes class that I teach over the years. I know that Brazil is very attentive to white-collar crime. I had a student who I was supervising a paper on the Foreign Corrupt Practices Act and its application in Brazil. So I know there's a lot of thought there, but I've also heard, as you said, that the corporate criminal legal system isn't very well developed yet. I would say that I could not, at least with respect to algorithms at this point, recommend the US as a model, whether for civil liability or for criminal liability, because I think right now the US has an accountability gap for both types of liability. Now, one of your sort of sub questions was, is it enough just to have civil liability? Do we need to have criminal liability as well? I think in terms of answering that question, it depends on this kind of gets into theory of criminal law, what it is that you think that criminal law does distinct from civil liability. What is it that we can accomplish with civil law? I don't want to get into that because that's very theoretical and philosophical. I have my own views. The answer is yes, you need them both always. But the one thing that I will say is, at least in the American experience, even if all you care about is preventing corporate misconduct, criminal liability is very important. Corporations seem to be motivated much more, or the managers running corporations seem to be motivated much more by the prospect of criminal liability than by the prospect of civil liability. Even though in the United States, the civil penalties that corporations face, the fines, the dollar values they have to pay, can be much higher than the criminal liability. It's a criminal conviction that turns repeat misconduct, that stops repeat misconduct. You have many cases where corporations engaging in a civil violation, they get fined civilly, another civil violation just repeats, they get fined, and then it's only when a criminal case is brought that they stop. I think the most recent example, BP is one prominent example that comes to mind, with several workplace safety violations they had over a number of decades in Texas. Another example that I recently read about last year was about these cruise liners who were dumping a lot of, I forget exactly which cruise company it was, but dumping a lot of waste into the ocean as they're going around, just letting their plastics go at the back. They were fined several times over many years. The thing that stopped them was when a criminal infraction was brought against them. And then they said, enough is enough. Sorry, that was longer than I meant to go on, Sophia, but thank you very much for the insights and the questions. And Gustavo, I look forward to hearing from you too.
Please, Gustavo, the floor is yours.
Well, I'd like to thank and congratulate the group for the excellent webinar organization, and also many thanks to Professor Diamantis for today's really enlightening class. And just one thing before the questions, Professor, I must also thank my colleague, Matheus Alencar, a scholar that studies this kind of topics you addressed today. And he also helped me yesterday with reflections upon your text that I had the opportunity to read to, and that was very interesting. And he helps me to think about the questions that I will pose now. But the responsibility and liability for the questions are all mine. Anyway, as I told you, I had the opportunity to read her text, and it was really impressive and mind-blowing, to use by Sophia's expression. And if I understood it correctly, and based on your presentation today also, when we consider employee misconduct, criminal sanctions and the responded superior model would work as an incentive to adopt compliance initiatives, codes of conduct, training of employees, etc. And something similar would apply to algorithmic misconduct, diversification of the computation and engineers, testing of the algorithm, and training also of the algorithm, monitoring, updates, and so on. Regarding employees and the compliance regulations in force, we seem to have some regulatory standards defined, whether internationally or nationally. Based on this, I have a group of questions that seem to me to be divided into two sets mainly. The first one, if I understood correctly your text, and please help me if I didn't. Who would be responsible for defining these regulatory standards for the proper functioning of algorithms and the prevention, detection, and reaction to algorithm misconduct? I mean, private sector, regulatory agencies, an intersection between these two sides, the public and the private side. How would it work? Not just who would be responsible for that, but what do you think this regulation should be? Would it be a general regulation? economic sector, specific regulation, or maybe a combination of those two ones? And do you see a difference or differences between compliance regarding employees? I mean, you said that there are differences, but what would be the difference between compliance for employees and algorithms misconducts, such as, for example, and I use here a text that Mateus suggested me to read from Professor Susana Aires from Portugal, and she talks about a sandbox, for example, a space where and when companies would be allowed to test their algorithms in practice and correct mistakes without being held liable. And this would avoid the discouragement of innovation and investments in technology. So this was the first group of questions. And based on that, I have a second one. And by that, I assume that I might be giving a proper reading of some works by Professor Laufer and by Professor Saad Nis here from Brazil too. And it might be just a reading of mine, but compliance for employees' misconducts would have led to certain distortions, either in enforcement. For example, smaller companies with lesser capacity to invest in compliance measures would be proportionally more convicted, given their lack of concrete capacity to adhere to regulatory standards or to implement an appropriate conduct after the infraction, or distortions in market competition itself. I mean, companies with this lesser investment capacity will have less capacity to adhere to these regulatory standards, and then they could not compete to the ones that managed to do it. The question is, do you see the possibility that this over-compliance regarding employees has similar effects with respect to algorithm misconducts as well? And if so, how could we avoid these distortions? How could we avoid that this liability do not produce this liability for algorithm misconduct? How could we avoid that it doesn't produce what clearly it's not its purpose, concentrating the market and discouraging innovation because of the distortions? Professor, if you allow me, I have one more question that I really would like to pose you. Several examples that I read in your text and today are examples of positive actions, I would say. I mean, when the algorithm would actually do something like commit a fraud in a public document, or say something racist in Twitter, I don't know, effectively doing something. And I wondered, how would this apply in the case of algorithm omissions? That is, in case the algorithm doesn't exactly do something wrong, I mean, positively do something wrong, but fails to do what it should. I could give two examples here, just to make it clear. First one, Facebook's artificial intelligence fails to prevent massive posts of fake news and hate speech directed at previously profiled groups, which can influence, and this can influence political scenarios in a given country or even influence elections. That is just an example. I mean, the algorithm does not perform it correctly, either because it does detect the activity as suspicious, but it doesn't understand it as a violation of the law or of the social network's rules, or it doesn't even detect it at all, what might be even worse, maybe. So would this liability model that you described this, would it apply also to cases like this, or cases of an algorithm omissions? And if so, based on what criteria, would it be the same or would be any difference? Another example, a vehicle with electric steering that understands the driver's driving patterns and tries to adapt to it, but the algorithm fails to make proper corrections in a situation of danger, such as the need for a sharp curve that the driver should do to avoid an accident. And the algorithm fails to detect this danger and fails to correct the movements that the driver made while driving the car. That is, the algorithm fails to make the proper correction, and that causes an accident. So also a case of what would be an algorithm commission. I mean, I'm trying to give examples to see if I make more if I make myself clearer. And at last, and sorry for the extension of my intervention, I was really fascinated by an excerpt from your text and also from your presentation when you talk about victims, and says in the text that the move toward automation does not alter the fact that discrimination, price fixing, and reckless driving leave victims in their wake. And end of quote. And that really fascinated me because one of the research lines we develop in the group here is corporate victimology. That is, how could we think about victimization within the corporate field? And I wondered if can we talk about a specific field of corporate victimology, maybe that would be algorithm victimology. I mean, thinking about a victimology and victimization by algorithms. And I understand your position against holding an algorithm liable, and your reasons are very convincing. But I don't know, just wondering, could we imagine an algorithm being the victim also in this possible field of study? I don't know. And here I thank Sophia for this reflection, this specific reflection about the algorithm as a victim. But I don't know. It seems to me that you opened a field that's very interesting and fascinating. And this is a broader question. I acknowledge it, but I would really like to hear if you see that happening, and what would be the insights you would give for someone that thinks about developing an algorithm or proposing some research on algorithmic victimology, whether in theory research or maybe empirical research, and all the difficulties because of the protected data of companies and so. But anyway, thanks for the presentation. Thanks for your text. It was really fascinating, and I really liked what Sophia said. Mind-blowing. Thank you so much. Oh, and Daniela asked me to let her speak. Victoria, I'm sorry. I received a message here.
Yes, I would like to ask Professor, if I may. I think Daniela would like to present a question just to finish this first panel of questions, because I think she's maybe out of time. So if I may, I would like to open for her to pose her question too.
Well, thank you, Victoria and Marin and Professor Diamantis. Actually, my question is very much related to Marin's question right now. So this is one of the reasons also that I really wanted to pose it at this moment. But first of all, thank you very much, Professor Diamantis, for the presentation. It was brilliant. I'm also not an expert in the field, but I like studying corporate crime. And one of my favorite texts today in the US is yours and Professor Laffer about the persecution of corporate criminality in the US. And the question that I have here today, it's quite a brief one and relates to Marines, but it's about how when you talk about compliance programs, we often talk about how big data, machine learning, and algorithms are the future of compliance. So like the innovations that are necessary for compliance in the future to be effective and to be, we have so much information when we're trying to analyze risk and data that it's very hard to do so without machine learning and without technology, and that it may be that one day that inside compliance we'll also have automated decisions that are actually better than human decisions, maybe or not. But what worries me is that, as you already wrote about extensively, and as you all know, like corporate criminal liability in our current prosecution of corporations and compliance programs is already failing. We have huge gaps in accountability, both in criminal, civil or administrative liability. And that's in the US already. If you talk about Brazil, it's another worse scenario. But what worries me is that I see that we try to regulate algorithms and that we're going to fall in the same thing. Like we're going to like write about how to do, I don't know, this is a view I actually wanted to know if you agree or what do you think about this view, if there's some sort of parallel that we might see in the future about how do we regulate our algorithms and how algorithms are created, and if there'll be like guidelines on how algorithms should be in order to be effective, and if not, there'll be liability, and if there'll be like a reduction of sanctions and so on. And then we'll be following the same sort of game that we have today with compliance programs. So yeah, I'd like to ask you, what would be your solution if in your liability scheme as a response to this problem? Thank you very much for the presentation, and Martin and Victoria for allowing me to pose my question now.
Thank you, Daniela, and thank you, Gustavo. And so I feel so privileged to have such great questions. Let me see if I can do them the justice that they deserve. I'll start by talking about kind of the theme of compliance that Daniela and Gustavo both raised, and I see kind of the fingerprint of Laufer over a lot of the questions here. That's nice. He's a good friend of mine. So I'm also a protege. I think we're all in good company here. There is a different burden that large companies and small companies face when they're trying to prevent misconduct, whether it's employee misconduct or algorithmic misconduct. In the context of employees, it kind of goes in two directions, right? Large corporations have many more employees that they have to keep tabs on, right? So they need a much bigger compliance program than a small corporation that might just have 3 people that they have to keep track of. On the other hand, the large corporation gets economies of scale because as they're designing a compliance program, they can just extend it, to apply to more people, whereas a smaller corporation doesn't have those same resources and might need 3 separate compliance programs for each of the 3 roles of its 3 employees. And so that's a pretty big burden on them. Now, one thing that just with respect to employees that I'm optimistic about, that Daniela alluded to, is that the cost of compliance for employees will get smaller and smaller as time goes on, as we develop more sophisticated, automated compliance systems using big data analytics and using machine learning to detect and flag incidents of employee misconduct. And also our ability to track employees is becoming more advanced. So just one example, although they only recently became employees, they're actually an example of this kind of independent contractor game that corporations had been playing, and then they were reclassified as employees. But we have a delivery company in the United States called Federal Express. They deliver packages to houses like DHL or DHS, and they were classified as independent contractors. But one of the things that by the corporation, the court reclassified them as employees, and one of the grounds for reclassifying them as employees was the kind of monitoring that FedEx was able to do of their conduct. So they had apps installed on their phones and installed in the cars that they were driving that monitored the drivers in real time. It filmed them, it tracked how fast they were accelerating, how sharp their turns were, what their rate of package delivery is, every single thing being monitored. Now, that's scary in a lot of ways, but as far as corporate compliance is concerned, it's a win because these are pretty cheap mechanisms to implement, and they give you much more data to look at. They narrow those agency costs that I was referring to in my talk. I think we'll see a similar thing with respect to algorithms. Right now, we're still kind of in the infancy of AI. And I think that the costs for developing and monitoring and modifying AI will go down as we get better at doing AI. Now, all of that said, two things I want to say, and they kind of go in opposite directions. One is, and this again is picking up on a remark that Gustavo made, from the victim's perspective, right? It doesn't matter whether it's an employee or an algorithm that hurt you. And it doesn't matter whether it's a large company or a small company whose car ran you over. You have a broken leg in either case. So from the victim's perspective, there's you don't care whether it's a small or big corporation. You just want justice. You want your leg paid for, and you want responsible parties to be held accountable. So that's kind of one direction that I'm pulled. The other direction is, and I think Laufer has written on this, I've written something related. The kind of compliance we might expect of large and small corporations might be different for exactly the sort of reasons that Gustavo was articulating. I think what we need from corporations is not perfect compliance, because that's unachievable. What we need is reasonable compliance given many different factors, which are the industry of the corporation, the history of the corporation, and the size of the corporation. That's one thing that should be a variable in deciding whether or not it had reasonable compliance in place. Now, all of this is to go back to something that Sophia was bringing up earlier, which is the US a good model for thinking about how corporate criminality might look in Brazil? And I think the answer at this point is no, because the US doesn't have that kind of sensitivity to these sorts of factors that I just listed. They just hold corporations accountable when their individual employees commit crimes. There's no compliance defense. There's nothing like that in the United States. No reasonable compliance defense, though a lot of people have advocated for it. I think, at least so far as criminal liability is concerned, there is some space for the sort of maneuver that you and Gustavo and Laufer are pointing towards, for saying, what is reasonable compliance given the size and the capacities of the corporation, and that can inform whether the corporation should be criminally liable. So far as civil liability is concerned, I personally don't think that should have an impact, because again, for the victim, they have a broken leg that needs paid for in either case. It's no more fair to have them pay for it, the victim, force the victim to pay for it if it's a small corporation versus a large corporation. So thank you very much, Daniela. I wanted to get to your question first because I think you might have to leave at some point, but thank you. I'll go back now to some of the other themes that Gustavo raised. The first was about regulatory standards and who would issue the regulatory standards. I will say that I think my general disposition is to be skeptical of regulation as a solution to business problems. I'm skeptical about it for two reasons. One, multiple reasons. I don't trust regulators. Two, I don't think regulators are necessarily in the best position to recommend standards. I don't think they're not the most expert in the industry. If they were the most expert, they'd be working in the industry. They'd be paid a lot more money than they are as regulators. The third is that regulation is all it's all forward-looking and kind of rigid, right? The whole point is to set forward-looking standards, but the world is much messier than a lot of regulations allow. Here's an example of the kind of case where I think regulation of the sorts of questions that I'm talking about here could go wrong. In the European Union, they're talking about mandating algorithmic transparency for certain types of algorithms that are making certain types of decisions that impact people. Okay, transparency means that you have the algorithm. It's kind of a machine learning algorithm. It's very sophisticated. And as I mentioned, a lot of times these algorithms, no human being can understand how they work. Okay, even if you can look at all the code, you still can't understand how it works. Even the people who designed it can't understand how they work. That's called a black box algorithm. There's another kind of algorithm, which is called, well, not a black box algorithm, the transparent algorithm. And this one where you can look at the code and you can see how any individual decision was reached, and you can explain it in terms that are comprehensible to a human being. So somebody says, I feel that I was discriminated against in this decision, and you can look at the algorithm's decision process and say, oh, look, yeah, you're right. Your gender did play a role, and this was a discriminatory decision. Or you can say, no, look, here's the decision the algorithm made, all the variables it considered, and this is why you were denied the loan that you wanted. So transparent algorithms, you can understand how they work. black box algorithms, you can't understand how they work. And the EU is considering implementing a regulation that would require only transparent algorithms in certain cases. Now, how could that end up going wrong? One way it could end up going wrong is that the regulation fails to appreciate that there is a trade-off that's made between using transparent or black box algorithms. There is a cost to using a transparent algorithm. Depending on the context, it's quite complicated, but there is a cost to using a transparent algorithm, and that cost can come to accuracy. So black box algorithms generally are more powerful and can make better decisions than transparent algorithms can. And so by mandating the use of transparent algorithms for certain very important decisions, you are necessarily requiring that you'll have more mistakes in the algorithms that make those decisions. And so this seems to overlook the fact that there is a delicate balance between costs and benefits for any particular algorithm and context. What's a different approach that you might take? The different approach you might take is to ask the corporations themselves to make the best decision for the context they're using it, whether a black box or a transparent algorithm is most appropriate. And the way you can do that is by setting corporate incentives right, so that, and there's a large section in a paper I just wrote explaining how to do this, but I think the way that you do it is by giving the corporations the right incentives to balance the social value of transparency versus accuracy. So that's kind of a long roundabout way of not answering your question, Gustavo, about who the regulator should be. I would prefer, I think, for there not to be a regulator. You mentioned in passing this very interesting point from Susanna about sandboxes. I think sandboxes could be a worthwhile enterprise. What is not good right now is when corporations are creating their own sandboxes in the real world. This is kind of how I see what Uber and Tesla are doing in their automated driver tests in major US cities like Los Angeles and Phoenix, right? They're treating these cities as their sandboxes for testing their algorithms. Setting up a more regulated space, perhaps, and definitely with some sort of insurance system in place, the corporations who are participating in the sandbox are paying into to compensate any victims. I mean, that sounds like something that could be worthwhile. Corporations need real data to train their algorithms and to improve them for social-wide, society-wide deployment. And so this is a kind of thing which I think might be necessary if we want to take algorithms to the next step. And then, sorry, just two more things that Gustavo brought up. Algorithmic victimology. I love the thought. I don't know what it means for an algorithm to be a victim. So in terms of thinking of algorithms as victims, I don't know what that looks like. Write a paper and send it to me so I can read it and understand. That could be a very, very interesting topic. There is someone, Christina Mulligan at Brooklyn Law School, who recently wrote a paper about punching robots or something like that as a mode of criminal punishment. But if you can punish an algorithm, then maybe you can also victimize an algorithm. So maybe that's one way that you might take that thought. There's a separate question, which is about what a victimology of human beings who are injured by algorithms might look like. And I think if we look around right now, again, we have very limited data, but I think we do see different types of harms right now, just given the state of algorithmic development, that people are suffering when it's an algorithm that's harming them versus when it's a human employee that's harming them. I suspect the gap between those will close as more and more things that corporations do are transferred to algorithms as opposed to employees. And then you have this last fascinating question about omissions rather than actions. And you point to some hypothetical examples, which are actually real examples, right? So your Facebook example, that's just Cambridge Analytica, right? And your driving example, misclassifying, that's kind of what happened in Phoenix with Uber. It's a little different, but there's similar examples. It just didn't correctly classify the pedestrian and didn't stomp on the brake, right, in time to save the pedestrian who was killed by Uber's self-driving car. But you correctly intuit the kind of response that I would want to give. I want to think of algorithms, and I think there's good reason to think of algorithms as being just like employees of the corporation. And so when it's a theory of liability that's based on a positive action of an employee, I'd want that same theory of liability to apply to algorithms. When the algorithm takes a positive step, we can think about the corporation's liability in the same way. And I'd say the same thing for omissions as well. If the theory of liability had an employee engaged in the misconduct been that the employee omitted to do something, and therefore the corporation is responsible, I want exactly that same structure of argument to apply to the algorithm, that the algorithm omitted to do something, and therefore the corporation is responsible. So I didn't talk about omissions, but it's a really provocative question. I think that's the direction I'd want to go. Thank you very much for all those. I hope I didn't take too much time replying to them all, but you guys gave me a lot of material to work with, so thank you.
Actually, Professor, the high-level debate just raised a lot of questions, and I would like to ask you, how much time do we have for maybe a second panel of questions? Yeah, I mean, if we've got more questions, I've got the time. I have to get off let's just keep going. Let's just keep going. When I have to get off, I'll say. Oh, thank you so much. So please, Carolina, if you'd like to present our question.
Sure. I will just turn on the camera here. All right. Do you hear me now?
Yes, we can.
Okay, perfect. So I'm super interested in what you're talking about. I'm currently studying the Apple case with the system detector, so child sexual abuse material detector, where it has launched a very serious discussion about the power of that algorithm identifying system file worldwide in relation to the American legislation with an American database. And when the discussion arises, so Apple has already said that it's not implementing that anymore, it will study that further and everything. I kept thinking about how problematic that could be to, for example, set a law enforcement report from a Brazilian device to NICMEC, so to American law enforcement based on American law. And I remember the case, if we are to discuss corporate liability here in Brazil, where there was an individual processing Facebook, bringing Facebook charge saying that Facebook has launched a law enforcement alert that has ruined his life because he was just looking for a club penguin, and the first two words were understood by Facebook's algorithm as child pornography, and his account was there marked as violating the terms of service for everyone to see. And of course, he was suspended from Facebook and could not come back with the same ID and everything. So I was just thinking about how far also those trust and safety algorithms that are used not to, for example, to provide content in the platform, to moderate the platform can create a problem of corporate liability. And of course, what Apple is saying, and I agree with Apple, it's much better to have a simple database. Everyone is being targeted for the same file than having an Apple worker saying what is child pornography and what is not. But could also create a second problem of discrimination. How do I say that this is child pornography and this is not? So I'm going to kick you out of my platform and let you here. So how does it apply? So in the American context, how do you see that, this Apple discussion and everything?
Thank you, Carolina. So this raises another topic that I'm deeply interested in, which is privacy law. And so I haven't decided yet what exactly I think about the Apple's proposed program. But I do have some thoughts about how I would go about developing a view. In the United States, there are certain different laws that apply to the government and that apply to corporations. There are different privacy protections. So a government, when it wants to access your information, a particular individual's information in the context of, say, a criminal investigation, they have to either have probable cause or they have to have a warrant from a judge. So special authorization to go through it. Apple, as a private corporation, doesn't have to get a warrant, doesn't have to have probable cause. You make your data available to Apple, it can take all of it. It can look at all of it, it can read all of it. So Apple can do whatever it wants and has been doing whatever it wants. But the thing which is surprising, which wrangled a lot of people about Apple's proposal, is that it's an intersection between government and private parties. Okay, it's because Apple is proposing referring to the government. So it's one thing just to say we're going to take down controversial images. We're going to censor. I mean,
I agree. I agree.
But when you start overlapping private and governmental roles, that's where you start getting some complicated dynamics. Now we have a law, a doctrine in the United States called the State Instrumentality Doctrine. It's something like that. But where the courts will say that a private party is acting as an extension of the government in certain cases. Now, our typical cases where this doctrine originated are where you might have an FBI agent who is standing in an airport by a baggage handler for an airline like Delta, right? And the baggage handler is seeing the luggage go by and the FBI agent says, I can't open that bag myself because I don't have a warrant. Would you open it for me and, so that I can see inside, right? In those cases, if there weren't an FBI agent there, the private airline baggage handler could do whatever they want without any violation. With the FBI there, the court says this individual baggage handler is acting under the influence of the federal agent, and so is going to be subject to the same standards we have for the government conducting an investigation. So the way that I'd want to think about this case now for Apple is I would want to think with respect to this image scanning algorithm, I feel there would be a pretty strong case for saying Apple is acting as an extension of the federal government, as an enforcement branch for it. And so I'd want to analyze Apple's conduct, not in the context of just a private party looking at images, but under the principles that would apply to a government doing the same sort of investigation. So that's kind of a start. Sorry.
Absolutely, no. Let me ask you something about it, because I completely agree with you that there is an issue if you are reporting that to law enforcement. And I myself, I have just written about it yesterday. I think that there is a problem, so specifically around child pornography, because in the United States, so Facebook, Google, everyone is scanning every platform, every single platform for those images because they are under the mandatory reporting law. And I don't know until which point, so can those mandatory report laws survive in the legal arena that we now have with privacy law? One thing is you're gonna scan everything and remove the files, but if you are reporting to law enforcement, then it creates a parallel confusion of encrypted platforms and everything that I'm afraid we cannot solve with the legal things we have now,
Yeah, yes, I think I agree. I mean, currently these things are occurring. But my sort of theoretical framework for thinking about them is that these companies are acting as extensions of the government. And so that's how we want to analyze them, about whether they're permissible or not. If we're okay with the government doing that, and that would be constitutional, fine, they get a thumbs up, at least under current law, in my view of current law. But if we wouldn't be okay with the government doing, then I think the practices should be modified to remove the governmental, the reporting requirements, or they should be terminated. And this is, and I had a student just last year who was writing about about child pornography and some similar sorts of laws on YouTube. And so I'm very aware of the, the deep damage and the pressing issue that child pornography is. I'm also aware of the threat of authoritarianism, that we have certain protections against the government to combat. And so we need to find a way to balance those. Thank you, Carolina.
Sure. Thank you.
So I think that maybe Osman would like to present a question too.
Hi, Professor. Could you hear me?
Yes, I can
Great.
hear you fine.
Great. Thank you for such a enriching and discussion, riveting discussion. It's been quite fascinating to hear your thoughts. My question relates to, and I'm a doctoral researcher in the United Kingdom. As soon as you mentioned your idea about, perhaps utilizing the doctrine of vicarious liability to hold corporations accountable for actions of their employees. A work of my old professor from UCL, University College London, came to my mind as well, because you've linked this with algorithmic accountability. I think Professor Martin Petrin at UCL, he's recently published a book and has a chapter on just generally corporate accountability for torts committed by subsidiaries and suppliers in those supply chains from the global north to the south. So I was just thinking about that and generally thinking what your thoughts are about our need to rethink the corporation's purpose from the doctrine of Milton Friedman to a more enlightened stakeholderism, and linking that with future algorithms being accountable. Because if corporations and the lead companies at the head of these multinational chains are held liable, then ultimately we can have another case for algorithms being held accountable as well. And perhaps whether in the future, when they do become so powerful that they are perhaps, an algorithm controlling a drone flying over Kabul, for instance, is making a decision about whether to take out, a particular terrorist. And, in the same house, there are kids as well. Whether that black box algorithm or the transparent one, what the sort of advantages and disadvantages of that are in that sort of a situation as well. So it is a very, very fascinating and important debate, I suppose. And yeah, so I'd just like to hear your thoughts on that, and the future generally of corporate accountability being linked with algorithmic accountability as well. Thank you.
That's really great, Usman. Thank you. I haven't thought much yet about the intersection between corporate purpose and algorithms. Obviously, they're going to be very implicated, right? Especially as corporations are becoming increasingly run by algorithms, right? So of course, corporate purpose and our thoughts about what corporate purpose is are going to have to, just as I think our doctrines of corporate liability have to update to the new mode of production, our conception of corporate purpose is going to have to evolve as well. I haven't had a chance yet to think about what the implications for corporate purpose are that algorithms raise. One place that I would look before going to corporate purpose with respect to algorithms and liability would be not necessarily to modify our understanding of what corporate purpose is, but to modify our understanding of what the boundaries of a corporation are. So as I understand current liability law, we think of corporations as being composed of individual employees. I think that, and this is kind of like one small contribution to that question that my work on algorithms is making, is that algorithms are also part of corporations. And so when an algorithm does something, it's just as though the corporation is doing it. Now you bring up Petrin's work. So one thing that I think, which is another formalism that corporations exploit, just as they exploit the difference between an employee and a non-employee for liability purposes, another formalism that they exploit for liability purposes is our legalistic definition of where a corporation stops and where its subsidiary or business partner or sibling starts, right? So that the corporation is directly liable just for what its employees do, but at best vicariously liable for what its subsidiaries' employees do. One of my ambitions is to take this framework that I've described for including algorithms in our definition of a corporation by looking at benefit and control, to thinking about other businesses that are currently regarded under the law as being separate entities, partners, subsidiaries, siblings, but perhaps understanding them for liability purposes as being part of the same corporate entity because of relationships with benefit and control that the larger corporation might exercise. So I think that might go some small way to addressing some of the concerns that you're raising, but it's certainly not the full story. Thank you, Usman. I think I maybe have time for maybe one more question before I have to go, Victoria.
Yes, for sure, Professor. I think Mateus would like to present 2 questions. Please, Mateus.
Good afternoon, everybody. Professor, thank you so very much for your presentation. It was really, as our colleague said, mind-blowing. I'm really happy to listen to you because, well, I am part of a development team. We use part of a Scrum framework to developing in the Rio de Janeiro DA office. And well, sometimes I have some bad feelings about what I do. And then you come and make them into a really brilliant lecture and a really good paper. And I thank you so very much for giving us that. And well, my 2 questions will be, the first of them is it's because I'm happy to have found another researcher that is also cautious but enthusiastic about technology. And that's how I see myself. And usually I see very pessimist people. They think technology will do harm to them. So in this case, according to what you have said, we usually use AI not only to inflict damage, but also to avoid damage. So we have this kind of deep learning used to attack viruses, digital viruses that can change their digital signature. So they can attack this kind of thing that other antiviruses can't do, or we as a human can't do. And in the Rio de Janeiro DA office, we have 2 algorithms that can actively find some kind of some harm to the public money, like, oh, they are here doing some bad things with taxes, and we can take them before they really do some great harm. And we have achieved more than 1 billion reais only with these 2 algorithms. So do you know any technology that is today used that is focused on algorithmic misconduct? Some kind of, oh, we have this kind of algorithm that can stop algorithmic misconduct. Do you know any of these? And if you could share with us, it would be great, because sometimes we should see that, oh, many problems are also solved with the thing that created the problems. And this same thing can solve other problems that we couldn't before. And that's why I am some kind of enthusiastic of technology. And the other question is really a fast one, but some kind of challenging for me, because you said you would prefer no regulation at all, no regulator to put things for those who are developing, as you said to Gustavo. But I think we still need some kind of basic regulation based on frameworks and basic good practice in development. Some kind like, well, we have training and testing, and people usually use the same database to test and to train. And it's not exactly a good practice, because if you do use the same database, you will have this algorithm trained in some kind of scenarios that are happy path, and then you test them in the same happy path. And this is really bad, and it is usually done. So isn't it good to have the state saying, oh, this cannot happen. You must have a 2-for-1 database and 2 database for testing, for training, and 1 database for testing. Different databases, different scenarios. And this look really important for me because we have problems with Tesla, we have problems with Uber, but we don't have the same problems with Waymo of Alphabet Google. And it looks like they are the ones that are testing so much more their autonomous vehicles. So this makes me a bit uncomfortable, and I would like so very much to listen to you about this kind of things, like using, oh, we use ISO or NIST or COBIT, like this basic framework with good practice to like a state regulation. What do you think about it? Thank you so very much.
Thank you very much, Matthias. It's clear you've thought a lot about these issues. So I'll say, you know, hope something which might be a little helpful or not. In terms of examples of algorithms that are used in enforcement, you might look at the SEC, Securities and Exchange Commission in the United States. We're using algorithms to monitor and track trading activity stock trading activity across the United States to catch potential inside trading and stock manipulation. That's one example, and so far as I understand it, it's a success story of using algorithms to help enforce. I'll just say another example, which so far as I know has not been leveraged by any governmental authority, but there are algorithms that are used to audit other algorithms for assessing whether they're engaging in practices of discrimination or not. So those are being actively developed. I'll mention maybe one more, which are algorithms that are used to monitor websites and other consumer software for potential privacy violations. That's another example of using algorithms as enforcers as well that I'm familiar with. You've pressed me to step back on the no regulation language. I'll concede. I was speaking bombastically there. I think we need some minimal regulation. But generally, I prefer, I would say I am skeptical of regulation where incentives can do a lot of the work. And where we do have regulation, I would encourage practices where it is a system where it sets a best practice where the corporation follows it or explains why it didn't. The SEC or NASDAQ has recently done a similar sort of thing. It's one of our trading platforms here in the United States, where they say in order to be a listed corporation, you have to have a diverse board of directors. You have to have at least, I forget if it's 1 or 2 members from minority groups, or explain to us why you don't. Okay, so it's an either, but you have a burden and to explain. And with respect to the specific example you gave in terms of algorithmic design, using 2 data sets, I would think that corporations ordinarily, just as corporations ordinarily should have an incentive in having a diverse board, because corporations with diverse boards perform better, corporations also should have an interest in having diverse data sets for training and testing. Right? Because you get a better algorithm that way, and they're trying to make a good algorithm. That's what their business model is, right? So they already have that incentive. Sometimes it's not enough. A regulation can help, saying you should have 2 data sets, but I would be hesitant to mandate that on pain of liability. I would instead say 2 data sets or explain why you can't, because there are some very important algorithms where there's just not enough data to have 2 sets. And so that can be the sort of explanation, just like the kind of thing you do for the IRB, Institutional Review Board, to conduct a human experiment, right? There are some potential harms, but the potential benefits of this experiment outweigh them. Similarly, you might accept, the regulatory authority might accept an explanation from the developer that, look, ideally we'd have 2 data sets. There's not enough data to do it, but look at the possible benefits that this algorithm could bring to society. It's worth proceeding even though we can't satisfy the recommended practices. So I think I would kind of go with that softer approach. Thank you very much.
Thank you so very much, Professor. You helped more than you could imagine. This is the last chapter of my PhD thesis, so I need
Very
so
good.
very much this talk. Thank you so very much.
So thank you so much, Professor. I think that maybe we'll have other questions, but if it's okay, we can send it later by email.
Absolutely, absolutely.
I'd like to thank you very much. Your answers and your presentation were all very inspiring for all of us. We had a very high-level debate with so many challenging questions that certainly had important reflections on the consequences of the algorithmic misconduct. So in the name of the Business and Human Rights Working Group, we thank you so much for the presentation and for your time. I want to thank so much for all of our colleagues, academics, professionals, all around the world joining us today too. And many thanks to our debaters, Sophia and Gustavo. We look forward to have all of you on the next webinars too. And thank you again, Professor Mihailis.
Thank you, everyone. This is a very stimulating session. You guys do great work here, and it was, I got a lot of good notes as well. So Mateus might have got some notes for his final dissertation. I got some notes for, the next couple of papers I'm going to be writing. So thank you very much.
Thank you, Professor. Bye-bye.